Donald Trump has just sentenced himself to jail, giving a clear pathway now for the judge to order his arrest after his latest late-night rant at Judge Juan Murch and breaking gag order and threatening him. Hacking part is what he mistakenly said. They got his MAGA followers crying like a baby, knowing that it's finally over for him after mentioning such words. We will show you the video clips. In this video of him ranting leading to his mistake that's making MAGA followers soaking tears that he's finally getting himself arrested. So make sure you don't miss out on the shocking video footage. Good day, dear viewers, and welcome to the daily newsletter. If you're new to this channel, please support by hitting the subscribe button. Also, please be sure to hit the bell button so you'll be the first to know when I drop a new video. Former President Donald Trump was awake until the early hours of the morning expressing his apprehensions regarding his criminal prosecution in advance of the closing arguments and jury deliberations that are scheduled to occur. The following week on Saturday, May 25th, 2024, Media Idaho reported on Trump's persistent assaults against Manhattan District Attorney Alvin Bragg and Judge Juan Murch. Throughout the trial, these attacks have occurred or jerk. Trump was particularly really irritated during the Memorial Day weekend and remained up until 2 a.m. to express his grievances, frequently employing all capital letters. President Trump cried out expensive legal expense at the stroke of midnight. He continued his outburst with a series of posts, one of which read, "Let's imprison the president for 150 years, because a bookkeeper called a lawyer illegal expense." The former president continued his tirade from that point on. A little more than 20 minutes later, Trump referenced an opinion essay that was published in the Wall Street Journal. He stated the Wall Street Journal opinion Albert Bragg has not presented his case within the context of the Trump prosecution. The evidence is unequivocal. The allegation should not have been filed in the first place. In spite of the fact that the New York prosecutors have spent 20 days in court and have a 4,000-page trial transcript, none of the missing pieces have been discovered this week when they decided to rest their hush money case against Donald Trump. Manhattan District Attorney Alvin Bragg's production of the evidence necessary for a conviction is one of the inquiries that must be addressed. The answer would be no if we were in the jury chamber, in an indication of his intention to remain on the offensive throughout the trial. Trump's early morning action began with an attack on RFK Jr. as the trial continued. The anxiety and high stakes that are associated with Trump's legal disputes are highlighted by the outbursts he has been having as the closing arguments draw near. Donald Trump is currently embroiled in increasingly heated legal disputes, and critics have recently advanced a novel perspective that he could have pursued his actions through legal channels. Legal professionals argue that this argument inevitably fails to meet expectations, despite the fact that it has some validity. The Daily Beast reported on Saturday, May 25th, 2024, that the alleged quid hush money payment made by Donald Trump to Stormy Daniels, which was facilitated by his former counsel Michael Cohen, has been the subject of much controversy. Critics have proposed that Trump could have lawfully entered into a hush money agreement with Daniels himself, thereby averting the necessity of Cohen's involvement and the subsequent fabrication of financial records. Conversely, there are numerous individuals who contend that this line of reasoning completely disregarded substantial legal complications. President Trump would have been required to disclose the payment in accordance with the federal campaign funding laws. If he had pursued a hush money arrangement, Directory's regulations mandate the disclosure of all contributions and expenses, including payments to individuals like Daniels that are made to political campaigns. It is undeniable that the disclosure of a $130,000 payment to an adult film actor during a presidential campaign would have elicited apprehension and would have necessitated an examination by the general public and a variety of regulatory bodies. In addition, the situation would have been further complicated by any contemporaneous gift from Trump that was intended to approximate the amount that was paid to Daniels. Legal analysts contend that Trump's actions were intended to evade detection and circumvent the stringent disclosure requirements of campaign finance regulations. In order to avoid notice, according to critics, Trump's deliberate decision to obscure the transaction's nature by passing the funds through Cohen and a shell company was an intentional attempt to obscure the circumstances surrounding the transaction. In order to preserve the credibility of his involvement in the arrangement and avoid scrutiny as a consequence of his actions, Trump sought to maintain plausible deniability. Legal professionals emphasize that Trump's objectives were unequivocal to circumvent accountability and transparency. This is despite the fact that Trump supporters may argue that he could have legally pursued a legal course for the hush money payment. Their argument is that the disregard for ethical standards and legal norms is indicative of a more extensive pattern of evasion of regulations regarding political money. The issue of whether or not Trump is in compliance with the laws governing campaign funding remains a significant topic of debate as Trump's legal challenges continue to unfold, referring to experts. Trump's actions indicate a concerted effort to evade detection and conceal his involvement in the problematic transaction. This is in spite of the fact that the legal route may have provided the situation with a facade of legitimacy. On Friday, May 24, 2024, Christopher Justice Coughlin, a Ball Joint New Jersey electrician who was convicted for his involvement in the Capitol riots on January 6th, hurled obscenities at the court that imposed a 12-year prison sentence for him. This penalty is one of the most extensive sentences among the hundreds of cases associated with the rebellion. And in 2017, former President Donald Trump appointed us District Judge Trevor McFadden to the court to whom his wrath was directed. His animosity is directed toward Coughlin, who is 38 years old. Coughlin reportedly informed the judge you are Trump's worst mistake of 2016. This was in response to a disagreement regarding the classification of January 6th as an insurrection. Politico asserted that Craig Lynn made this assertion. McFadden referred to Coagulant as a menace to our society for his vicious assault on numerous police officers during the Capitol siege, after administering the severe penalty. This resulted in the contentious debate that ensued. On that particular day, Queensland was one of the most violent demonstrators. According to the prosecution, Quigley continued to disparage and argue with the judge that Trump had appointed. Following the sentencing, he executed this action both prior to and subsequent to his sentencing. He expressed his dissatisfaction with the conditions of the prison and advanced conspiracy theories regarding the 6th of January when he was granted the opportunity to speak. Before the sentence of 12 years in prison was pronounced, McFadden cautioned quite line that his belligerent behavior was a really bad idea. He continued his meandering remarks. Coughlin responded by characterizing the proceedings as a kangaroo court. Cleveland issued a social media statement subsequent to the sentence's delivery, describing his involvement as a wonderful experience. He added it was a bump and a bruise for me. Additionally, we are enjoying ourselves immensely. During the 3 years that he was in custody, his defense attorney contended that he was not provided with adequate medical care. Furthermore, he stated that his former attorney compelled him to participate in a stipulated bench trial rather than a jury trial. The fracture lines.